We will call this meeting of the TDLR Midwives Advisory Board at 10:01 a.m. I will ask everyone to mute your microphone and only turn them on when it's your turn to speak. Please keep your cameras on and announce your name when you're speaking so your names can be recorded. We'll go to item B. Carmen Marshall will conduct the roll call.
Yes, ma'am. Kristen Bowers,
Present.
Gretchen Robinson,
Present.
Jennifer Kelleher,
Present.
Michelle Gold,
Present.
Melissa Bates,
Present.
Dr. Guillory,
Present.
Dr. Nix,
Present.
and Presiding Officer Destiny Hooper.
Present.
You have a quorum.
Since our last meeting, we have 3 new members appointed to the board, Jennifer Kelleher, Gretchen Robinson, and Kristen Bowers. If any of you would like to share a few words, you can do so now.
Guess I'll go. Gretchen Robinson. I have been in birth work for 15 years, licensed midwife almost 8, and I'm a mom to 8 myself. And I'm thrilled to be a part of this and to learn and hopefully to contribute. Thank you.
Hi guys, my name is Kristen Bowers. I've been a midwife for almost 5 years now. My background was actually in forensics, not midwifery, and I just kind of fell into this after having my son. Um, and so I'm really excited to perhaps bring a different viewpoint, but and hear everybody else's viewpoints. So, yay.
Good morning. I'm Jennifer Kelleher. I have been in birth work for about 28 years, licensed midwife for 22. I practice out of San Antonio, Texas, and I am super excited to be part of this crew to improve midwifery across the state.
Thank you all for sharing. We'll now go to the open government training, item C, and I will call on Assistant General Counsel Athena Ponce for the presentation.
Good morning, everyone. My name is Athena Ponce. I'm an Assistant General Counsel with TDLR. Can you all hear me? I'm the Assistant General Counsel for the Midwives program, and this morning I will be providing the statutorily required open government training. It's going to be a PowerPoint slideshow, and I am going to share my screen in just a moment, go through the slideshow. It is a bit lengthy and covers several topics, so we'll be patient and get through hearing me talking through a bunch of legalese, and I hope you all find it informational, and if you all have any questions, feel free to let us know during the presentation or at the end. So I'm going to share my screen now, and hopefully there won't be any technical difficulties. Can you all see this blue slideshow with Midwives Advisory Board?
Yes.
Okay. So this is the Midwives Advisory Board Open Government Training. Like I said, I'm Athena Ponce, Assistant General Counsel, and I work on the Midwives program. Training overview, this will include the Open Meetings Act, the Administrative Procedure Act, and the Public Information Act. Nuts and bolts of the Open Meetings Act are to follow. The purpose of the Open Meetings Act is to ensure open and transparent government. The Act requires meetings of governmental bodies to be open to the public and to be preceded by public notice of the time, place, and subject matter of the meeting. The provisions of the Act are mandatory and are to be liberally construed in favor of open government. A quorum is a majority of the members of the advisory board or committee as fixed by rule or statute. A quorum of a governmental body, including an advisory board or committee, must meet in order to take an official action. If less than a quorum meets, the board or committee may have discussion but may not take any official action, such as a vote after a motion, for example. Deliberation or discussion means a verbal or written exchange among a quorum of a governmental body or between a quorum of a governmental body and another person concerning an issue within the jurisdiction of the governmental body. So to provide some clarification, I know deliberation as described here may sound a little vague, but even things like emails or messages sent electronically would fall into the category of deliberation if a quorum of that body is taking part in that discussion through those messages. A meeting occurs anytime a quorum of a governmental body engages in deliberation regarding public business or public policy over which the governmental body has supervision or control, or any time the body takes formal action. The Act requires advance written notice of the date, time, place, and subject of each meeting held. TDLR provides this notice in the form of an agenda. Notice must be filed with the Texas Secretary of State at least 7 days before a meeting and must be posted online both by TDLR and the Secretary of State. A board or committee may not engage in discussions about a subject not included in the agenda. What about social functions, conventions, and workshops? Keeping in mind that a meeting occurs whenever a quorum of a governmental body engages in discussion about an issue within the governmental body's jurisdiction, can members ever meet in an informal setting without violating the Open Meetings Act? Yes, members are free to engage in conversation that is incidental to the event. However, the discussion will be subject to the Open Meetings Act if a quorum of members is involved and the members either engage in a discussion or make decisions about board or committee business or take formal action. Key points to remember. Always be aware of any situation occurring outside of a properly noticed meeting in which a quorum of members is present or engaged in discussion. Do not engage in substantive conversations relating to board or committee business or policy when a quorum is involved and you are outside of an officially noticed and scheduled meeting. Beware the walking quorum, and that means what has just been described here, a quorum, enough people of that body to meet the quorum number and engaging in discussion outside of an openly noticed meeting. A walking quorum occurs when fewer than a quorum of members engage in discussion about official business and then communicate those discussions to other members. While fewer than a quorum of members participate in the initial communication, subsequent communication with other members will result in a quorum discussing official business outside of a public meeting. So if the discussion starts with a small group of members, say 2 or 3, and then more members get added to that same discussion, that can result in a walking quorum. On a 5-member advisory board, 2 members exchange phone calls and emails expressing thoughts on an upcoming rule change and exchange research that they have each individually performed regarding the issue. One of the board members subsequently forwards the exchange to another member. The members have now engaged in a walking quorum by engaging in a small group discussion outside of a properly noticed board meeting. So that's an example of the walking quorum that's been cautioned against. Walking quorums can occur during conference calls, video conferences, hallway discussions, emails, text messages, and other new technologies. The walking quorum concept, combined with newer technologies such as Twitter, Facebook, and instant messaging, raises new issues about meetings and compliance with the Open Meetings Act. Best practices to avoid a walking quorum. To avoid a walking quorum, members should not meet in small groups, discuss board or committee business, and then communicate those discussions to other members. Send emails or text messages to a quorum of members regarding official business, even if each email is addressed and sent to each member individually. Create posts on social media about board business where a likelihood exists that a quorum of members could participate in discussions, or ask a quorum of members, even on an individual basis, for feedback or comments on board or committee business outside of the public meeting. This is also called polling, which is essentially conducting an informal vote on an issue. Guidelines for open sessions. A board or committee is limited to discussing the specific items on the agenda. During the public comment portion of the meeting, members of the public are given an opportunity to speak, and the presiding officer may set reasonable limits on commenters. A member of the public or a member of the board may raise a subject that has not been included in the agenda. However, discussion of the subject must be limited to a proposal to place the subject on the agenda for a future meeting. Guidelines for open sessions best practices. To avoid violating the Act on the basis of insufficient notice, members should limit discussions to the specific agenda items contained in the posting filed with the Secretary of State. Avoid allowing discussions regarding specific agenda items to wander off course into new issues that have not been noticed to the public. Not respond to or discuss issues that are raised during public comment but which are not on the agenda. And specifically identify items for future agendas and communicate those items to TDLR staff. And so you probably noticed in the agenda today, there is a specific item for identifying future agenda items, and that is the opportunity where this would come up. Penalties and remedies for Open Meetings Act violations. Civil remedies. Any interested person, including the media, may petition the courts to stop actions taken in violation of the Open Meetings Act. The Open Meetings Act also specifically states that an action taken in violation of the Act is voidable. And so voidable means that possibly they would have to engage some sort of legal action to seek that the act that was taken in violation of the Open Meetings Act be undone. Penalties and remedies for Open Meetings Act violations also includes criminal penalties. Members who knowingly participate in a walking quorum or who knowingly participate in a meeting that is closed to the public are subject to misdemeanor criminal penalties. The penalties are a fine of $100 to $500, confinement in county jail for 1 to 6 months, or both the fine and jail time. Open Meetings Act best practices include: avoid communications that involve a quorum of board or committee members about official business outside of a properly noticed public meeting. During open meetings, confine discussion to items specifically posted on the agenda. And here are some resources about the Open Meetings Act, including the Texas Attorney General Open Meetings Training Information and Video with a link, Texas Attorney General Open Meetings Handbook with a link to Texas Government Code Chapter 551 Open Meetings, as well as the phone number to TDLR General Counsel's Office. Our next subject is the Administrative Procedure Act, and we'll cover nuts and bolts of this subject. The purpose of the Texas Administrative Procedure Act is to establish minimum standards of uniform practice and procedure for state agencies and to provide for public participation and transparency during the rulemaking process. A rule is a statement of general applicability made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. A rule excludes a statement regarding only the internal management or organization of a state agency and not affecting private rights or procedures. A rule includes a new rule, an amendment to an existing rule, and the repeal of an existing rule. Sources for rulemaking are legislative changes, such as statutory updates after the legislative session, advisory boards, TDLR staff, four-year rule review, and rule petitions. A rule petition involves where any interested person may submit a petition to a state agency requesting the adoption of a rule. An interested person is anyone who is a Texas resident, a business entity located in Texas, a governmental subdivision in Texas, or a public or private organization that is not a state agency but is located in Texas. Here's a chart showing the steps and the process of the Administrative Procedure Act rulemaking process. We start up in the upper left with rule idea and drafting, to internal review and analysis, a review by the governor's office, a first advisory board meeting. Then proposed rules are filed with the Secretary of State and plain talk summaries are posted online. The proposed rules are published in the Texas Register. There is a 30-day public comment period that follows that allows the public to give their input about those published proposed rules. There's a review of public comments, then a second advisory board meeting. The proposed rules are adopted at the commission meeting after that, and an adoption notice is filed with the Secretary of State and published in the Texas Register. And then the rules will take effect on the published effective date of the rules. The Administrative Procedure Act rule review process involves programs that are on a 4-year schedule, a notice of intent to review. The public has 30 days to comment on that program or that, that profession. The General Counsel reviews comments and makes a recommendation to the Commission. The Commission reviews rule filings and comments and may readopt the rule. And the Advisory Board will be presented any comments and may recommend changes. These are some rulemaking resources: the Texas Attorney General's Office Administrative Law Handbook with a link, Texas Government Code Chapters 2001, 2006, and 2007 with links, Secretary of State website with the Texas Register and Texas Administrative Code, and the phone number for TDLR General Counsel's Office. We'll cover the Public Information Act nuts and bolts now. The Public Information Act, or Open Records Act, is intended to allow public access to information about the affairs of government and the official acts of public officials and employees. The Act makes all documents, records, and other information relating to official business open to the public with some exceptions. Public information includes any electronic communication created, transmitted, received, or maintained on any device if it is in connection with official agency business. The Act should be construed liberally in favor of granting requests for information. The open records process involves requests for public information. The public may request copies of public information or request to inspect the information in the offices of the governmental body. A request must be submitted in writing. At TDLR, a request must be submitted through the TDLR Records Center, which can be accessed on the TDLR website. A prompt response is required. TDLR must respond to the request as soon as possible, but not later than 10 business days after receiving the request. We cannot ask why someone wants the records. We can only ask for clarifications through the General Counsel Open Records team. General rules and common exceptions to disclosure. The general rule is a presumption of openness. Certain information is required to be redacted from open records. Examples include dates of birth, most email addresses, driver's license, license plate, and VIN records, credit card numbers, HIPAA information, and Texas Medical Records Privacy Act information. An OAG ruling must be sought to redact or withhold other information. If a request is received by an advisory board member, as an advisory board member, if you receive a written request for records or correspondence that looks like a public information request, please forward the request ASAP to the advisory board team, who will forward it to the Office of General Counsel Open Records team. If the General Counsel Open Records team requests information from you as an advisory board member, please respond as soon as possible. The 10 business day deadline applies to all requests. These are some resources on the Public Information Act, Texas Attorney General Public Information Act Training Information and Video with a link, Texas Attorney General Public Information Act Handbook with a link, Texas Government Code Chapter 552 Public Information and a link, the phone number to TDLR General Counsel's office, and the TDLR Open Records Policy, which is linked. And that is the end of the presentation. Are you all fine with my ending the screen share?
Thank you, Ms. Ponce, for sharing with us and updating us with all of the open government trainings. We will move to the approval of minutes, agenda item D, for the meetings of June 12th, 2023 and October 30th, 2023. Do anyone have any comments? So move to
I make a motion to accept the minutes.
and can I get a second?
I'll second.
Thank you.
Who was that? I'm sorry. Who seconded?
Sorry, my apologies. It's Michelle Gold, second.
Thank you.
So Carmen?
Would you like me to do a roll call?
Yes, please.
Okay. Kristen Bowers,
Present?
you're for the approval.
Yes, that is correct.
Gretchen Robinson,
Present. Approved.
Jennifer Kelleher,
Present, approved.
thank you. Michelle Gold,
Approved.
Melissa Bates,
Approved.
Dr. Guillory,
Approved.
Approved.
and presiding officer Destiny Hooper.
Approved.
Motion passes.
Thank you. We'll move to agenda E, public comments The Midwives Advisory Board received 3 email comments that were emailed to the board before the meeting. The comments will not be read during the meeting and cannot be discussed. We will move to Agenda F, the staff reports. I'll call on Charles McCain for License and Permit Specialist Lead for the statistics.
Hi, good morning, Advisory Board members. My name is Shara McCain. I'm a team lead of Health Professions team, and I will be providing to you the staff report for Midwife program. As you can see on the report in front of you, for the fiscal year 2025, we issued a total of 49 new licenses. 173 licenses were renewed, of which 99% of these renewals were renewed online. The total population for fiscal year 2025
report. I actually do have a few clarifying questions so that I can understand about the renewals. Um, if a when these renewals are all going through, does this include renewals that are currently being audited, or is this just a all renewals across the board, like or just the renewals that were completed?
These are the renewals that were completed as of the first quarter of 2026.
Okay. Um,
And then the
if
audits,
a
the
yes.
continuing education audits is being done by our education department.
Okay, so that would be under a different report.
Yes.
Okay. Uh, that
Thank
is all.
you.
Thank you.
Thank you. All right, I will
Thank you.
call on the Education and Examination Division, Michael Ford Strawn, Director, for his statistics.
Good morning, Chair and members. My name is Michael Strawn, and I am the new Director for Education and Examination, recently started. So before I get into the stats, I just want to kind of take a second, highlight some of the initiatives we have here. I'm a big proponent of communication amongst everybody, and so I'm here in front of y'all today, kind of talking about the direction of education examination moving forward. We want to really take a basis on what we're bringing forward to you, presenting you more data. So the report you see today is not the report you will get in the future from us as well. We're really going to be trying to highlight all the initiatives that our team is doing, the projects they're working on, whether that's updating the website, getting you an updated user or manual out there for midwifery that's up to date, has current information. Some of those charges you're really going to see. I know that Ms. Bowers, you were just asking about the continuing education numbers. Those are numbers that are not on the statistics because they haven't been here before. But if y'all would like to see that information, we can certainly make sure that that information is included in this report moving forward as well. So happy to talk about that and answer any questions I potentially can. I am still new down in this area, so I will do my best to get you the answers as soon as possible. And let me roll into my report here, and then I'll open up to any questions. So as you see below, jurisprudence examinations, this is for our individuals that are coming in and taking this to do the Texas laws and rules. We only have about 3 months so far, but quarter one is a little bit lower than we saw for quarter one in 2025. Not a real explanation for us on that point, but if you'll move down to the next portion of our numbers. Here is our midwife school curriculum. You'll see we had 4 to start September 2025, but we leveled out in main 2 curriculum since that time. That has moved all the way through FY25 into FY26, and those are the 2 we still remain. As I conclude my report, that's all that we have as far as data today for you. I'm open to any questions that you all have moving forward.
Hi, Michelle Gold here. I have a question. Just to clarify what you said about adding to the reports and communication and kind of adding more into that, which is great. Thank you. I appreciate that. When you say that you can add the CE audits to that report in the future, I guess in the future, because not everybody will be audited, you'll put on there like who is in the process of being audited for each quarter and for each fiscal year.
We probably wouldn't have the data on, if you're asking for specific individuals up for audit,
Right.
but percentages, the numbers
Yes.
of volumes per month, everything else
Yeah.
we'll try to break out for you all. Yes, ma'am.
Yes, that would be great. Awesome. Thank you.
Dr. Guillory, do you have a question?
Yes, Mr. Ford, in terms of adding any information in both of the reports, is there any way, are you keeping a record of where most of the midwives are practicing, which counties or that they're in?
I don't believe that my division is doing so. If that's information that interests the board, we can certainly talk with our staff. Licensing may have that information as well and see if we can present that to you all. I don't have that data at hand, though.
Okay, thank you.
Ms. Bowers, did you have a question?
Yes. Going back to I know that you don't have the data today, but for the data that's going to be collected, is there going to be a way that we can track the processing times for audited renewals and could those metrics be shared at a future meeting as far as how long it takes from the time one is audited until it's going through?
Absolutely, and right now, just so you're aware, renewals are not being held for the audits that are taking place. But certainly, any data that you all want to see, we'll be happy to provide it if at all possible. I know tracking those key performance indicators, KPIs, is important for us. We want to work not only the people side of the aspect and make sure we're serving the people, but making sure that we're being timely, meeting those demands as well. So. We'll take that into consideration for our updated reports here moving forward, which hopefully our next advisory board report is not too far off, and we can make sure that we're providing that to you all and with as much detail and granularity as possible.
Thank you.
Yes, ma'am.
Michelle Gold here again. Hi. You just said renewals are not being held up by the CE audits. Is that right? Is that what you said?
Yes, ma'am.
Okay, great. So members who are currently waiting on the feedback from their audit, they can, if their renewals coming up, they can go ahead and proceed as normal for the renewals.
Yes, ma'am.
Okay, great. Thank you.
Following up on that question, if an audit is open currently in a system and they're if there was an attempt to renew, and this might just be a clarification, is that an upload on y'all's end to the system there, because it seems like when there's an audit that's open, it doesn't have the option for the renewal.
Ms. Bowers, I'll follow up with that. I don't know offhand as far as it was explained to me. That shouldn't be the case. It's if you haven't, if you haven't complied with a former audit, by the time you get to the next renewal, it could impact that. But in the current one, no. And so I'll double check that information is correct. I'll get it back to you here shortly.
Perfect. Thank you so much.
Is there any other questions?
Is there a current way to search whether your specific license is under audit?
To my knowledge, I'm not sure outside of the notification you've received from the department. There should be when you log into the system. I will follow up, and I apologize. Some of that's going to be my greenness in this process over here, but I will definitely make sure that we can get that for you.
Thank you.
Gretchen Robinson, just to answer that question. Oh, there goes my video again. I don't know what is going on with this thing today. If a individual midwife were to log in and review her licensure, such as search for her licensure or attempt to renew, go to the renewal screen, then we can see if we are under an audit, if our audit is pending, I do believe, I don't remember if it was Michelle or not, but the renew your license was grayed out if you were pending in your audit status. That was quite some time ago. I don't know if that's still the case, but we can log in and we can see our status on an audit if we're due for one, if we're pending, if we're completed. It doesn't really give us much more information than that, though. As far as if the general public can search for that, I don't think so.
Okay, thank you. That helps.
Michelle Gold here. So if it is grayed out for people who are currently undergoing the CE audit, is that something that you can also follow up with us on?
Yes, ma'am. Michael Strawn,
Okay.
education examination. I will definitely follow up with you. From what I'm understanding, for the system and what my staff is telling me at the moment is that they may not be in renewal when they see that they're within that audit, and that may be why it's grayed out. But certainly, we'll double check, make sure that that is functioning correctly, and get back with you.
Okay, thank you.
Yes, ma'am.
Okay, if there's no further questions, thank you all for your attention to the details on this. We will move on to customer service. I'll call on Claudia Enriquez, the customer service manager, for her statistics.
Hi, good morning, advisory board members and TDLR staff. My name is Claudia Enriquez, and I'm the customer service manager for this program. As you can see in our report, the overall customer service contacts in FY 2026 remain consistent with those from FY 2025, averaging about 29 contacts towards the end of the calendar year, which includes December data that was not available at the time the report was due. Aside from those statistics, that concludes my report. I'm happy to take any questions you may have.
Are there any questions for Ms. Enriquez?
Can someone clarify what a customer service contact would represent?
Yes, customer service receives calls. They can range anywhere from needing help with the application process, clarification, wanting to see if a document was received by our office, or a license status request.
Perfect. Thank you.
You're welcome.
Okay, there's no further questions. We will move on to the enforcement division. I'll call on Shauna Almashuk, the prosecutor, for her statistics.
Thank you. Good morning, board members, and welcome new board members. My name is Shauna Almashuk. I'm a prosecutor for the Enforcement Division. I'll be presenting the report for you today. You may notice that we've updated the Enforcement Division's report from the last meeting. Today, I will cover key statistics and case highlights. At the very top, you have the division's performance measures, which are reported to the legislature. You may notice we've reorganized the materials so you can compare one fiscal year to another more clearly. And you'll notice that the average time for closing complaints has decreased significantly from the same time last year, now that we have more experts. We currently have 4 experts and are still taking applications if anyone is interested in being an expert. The next section is the criminal history review for applicants who may have disqualifying criminal history. And as you can see, none of the midwifery applicants were denied licenses based on their criminal history. And those cases are handled by our criminal history prosecutors. The next section details where the enforcement division's complaints come from, whether they're from consumers or from within the agency. And the top of the next page puts this into a pie graph for you based on the cases that were opened from the complaints received. The next section details our caseloads within our enforcement division. The orders issued are the end of the road for the disciplinary action where the person admitted they made a mistake and paid an applicable fine. The penalties and consumer remedies detail how many fines were assessed versus actually collected and shows you the average penalty on these cases. The top of the next page shows the rationale for cases that were closed without disciplinary action. And then the next section details alleged violations at opening. And these are just the reasons the case is opened on the front end. And then the very last section details the violations which resulted in disciplinary action, the type of cases that we took action on. And then at the bottom of this page and the top of the next, I've added 2 case highlights to provide an example of complaint cases that were resolved by department staff for your review. This concludes my report, and I'm available to answer any questions you might have.
I'm sorry, Charlita Guillory. I missed the measurements you said that are being presented to the legislature. I didn't see that. I apologize. Could you review those measures? I see them. Good. Thank you. And the other question is, I see these are predominantly complaints. Do you have are the complaints about the care? Are the complaints about the delivery? I'm not sure. Do we have any records of that?
So if you, I believe it's on page, the second page at the bottom, it'll indicate, no, I'm sorry, it's the third page, sorry. At the top of the third page, yes. Oh, the alleged violations. So that'll tell what was being alleged at the time of opening. So either there were no protocols being used or incomplete or wrong protocols being used, whether the individual was unlicensed, whether there was an unsafe or unclean environment, the criminal history, and then if there was a referral violation. We have other, there may be some other categories as well, but those are the ones that were related to the complaints that we've received so far this year.
Michael Nix, I have a question about that. So if there was a complaint about a poor outcome, where would this show up in this alleged violation?
It would be in the no or incomplete or wrong protocols.
Okay. So of these that we see in each fiscal year, there were 2 violations or alleged violations for that could be related to poor neonatal outcomes or poor maternal outcomes.
Correct.
Okay. Do we know, as I look and see, there has been an improvement in the number of days that it takes to close a case. Do we know of those 2 outcome cases, how long it took to close those specific cases? Because those are the ones that seem to have the utmost priority. And those are the ones that I think would be the most interesting to know how long it takes to close those cases.
Thank you for the question. This is Shauna Almashuk. So we have a prioritization where we prioritize cases that are with bad outcomes, specifically infant death or maternal death or brain injury or any thing that's very severe in that nature that you're referring to. And those cases get looked at first. We have had, I can't say specifically on those 2 cases, how long it took to get them to completion. I do know that there was a period of time where we really struggled with having experts, and that prevented us from moving cases forward very quickly. But now we do have, as I mentioned before, we do have 4 experts on board, and we are moving our cases much faster now.
Michael Nix, thank you for that. and I want to make sure that I understand this data correctly as well, is in the last 2 years, there's only been 4 complaints or 4 complaints of maternal or neonatal bad outcome, because there's only 2 allegations in FY 2025, 2 allegations in 2026.
I understand the question, but I don't understand the statistics in a way that I could explain them to you in this moment. But I will get a better explanation for you and provide that to you as soon as possible.
It just seems like a low number to me, because previously we had been dealing with much larger numbers than those as far as allegations of outcome. And those are, to me, the most important thing in all of this process. We are directly involved, or in this provision of this health is directly involved with moms and babies. And it's just the most important thing that we do. That's all that this is about.
I definitely agree with you. This is Shauna Almashuk. I'm sorry. So I am noticing in this on this section, it says the top midwifery alleged violations at opening. I do know that on the first page of the report, it does list multiple complaints opened. And this is actually only during a specific part of the year. It doesn't cover the entire year. So it's only August until August of 2025 until actually I think until March. No, until December, excuse me. And then so it only covers a couple of months. And then that's the same period of time for fiscal year 2025. So it's not a full fiscal year.
Michael Nix again. Has the method or avenue for complaint changed over the last few years? The way that complaints are registered or brought forth to this or previous organization, is a similar method also to the previous organization? And what I'm referring to is the midwifery board before the moving over to TDLR.
I don't have that information. I've been with the agency for 2 years, so I can't speak to that, but I will get that information as well and provide that to you.
Charlita Guillory, one quick question. As Dr. Nick said, the outcomes tend to be one of our major issues and the things that we should be following. When you have number of complaints opened, is there any way that you can actually just get to that information about the neonatal outcomes or the maternal outcomes and have it named that? Here it's kind of hidden. And I'm not sure how to, I would appreciate any information you could give me on that.
I can get more detailed information for you. I know that the software that we use, there's specific things that we identified the basis of the case for, and I don't know if we have it that detailed, but I will see what I can find out and we'll get back to you with that information.
Thank you.
Yes, ma'am.
Kristen Bowers here. I would like to get a clarification, perhaps. I think maybe a misunderstanding. On the portion that says alleged violations as no protocols or wrong or incorrect protocols or incomplete, um, that could extend to things beyond poor outcomes, correct? I mean, it
Yes.
doesn't we're not saying that those two alleged violations are in fact a neonatal or maternal, poor outcome. Is that a correct assessment?
This is Shauna Almashuk. Yes, that is correct. It could be failing to transfer, but there was not a bad outcome, for example.
Okay.
But I don't know
I'm
for sure
assuming.
which these two.
Okay, I'm assuming it could also be if you were doing the investigation, then it also might be something as simple as when you were investigating, they didn't follow one of their protocols that they have. Is that correct? So if they had a protocol for addressing a certain um, antepartum issue and they didn't address it appropriately, would that also fall under that? Okay.
This is Shauna
Uh,
Almashuk. Yes, that's correct.
okay. So then I guess my follow-up question would be um, similar that if we're having a complaint that's open because of a poor outcome, that would be listed under a separate allegation. And since I know these are only opened, it's only listing what the allegations are when they're opened, but it was showing right here that there are still 43 pending cases. Is that correct?
Yes, that is correct.
Is there any way to get a breakdown of the 43 that are still pending so that we can see uh what exactly the allegations are, even if they are not open? Because I mean, I don't know when those 43, I'm brand new, so I don't know when those 43 were necessarily opened or what they were categorized, or even if they were categorized, if we had such a detailed report at that time. Is there any way to get a breakdown of those 43 complaints? Like, are they just, paperwork, or is it because we really had poor outcomes many times?
This is Shauna Almashuk. I can tell you that the cases with the highest priority are being reviewed first. And the 43 cases may include some higher priorities. However, I believe that, well, to answer your question directly is, I don't have that breakdown. It is potentially possible that I could get that for you and get that to you at another time. I do think that of those 43, I can say that I know for sure that the priority cases, the higher priority cases, are being worked over the lower priority cases where there were no, or not necessarily no bad outcomes, but minimally bad outcomes.
Okay. Um, and then I guess just as a follow-up question for when the complaints are opened, I know that we're tracking how they're being opened, whether it's a consumer or if it's something else. How is consumer defined? Does it include just patients? Is it including other healthcare providers, facilities? Is there any way to get a breakdown of who the consumers are? Are these reports that are coming in from a hospital after a transfer, or is this coming directly from the patients or the clients themselves?
So this is Shauna Almashuk again, and the answer is yes, it's all of it. So the consumer is any public person that is not an employee of the agency. So it could be law enforcement, it could be a doctor, it could be a physician, I mean, a nurse in a hospital, it could be another midwife, it could be a client, it could literally be anyone would define the consumer. And I would also need to get see if I would be able to get a breakdown. I'm not sure if we have that, but I can look into that for you.
Yes, Destiny Hooper. For informed consent purposes, I think it's really important that we have more transparency in the data about who the consumers are and what the actual outcomes are instead of just poor outcomes, or the way it's worded, it's too broad of a category. We need to have it like break down what those outcomes were, I think.
Shauna Almashuk, yes, I understand. And I will I will do my best to get all this information back to you guys as soon as possible.
Gretchen Robinson, I have a quick question. Under orders issued, the first one is listed agreed orders. Would you be able to give me a brief explanation of what an agreed order would be? I understand the majority of the other ones.
This is Shauna Almashuk, yes. So an example of an agreed order would be assuming a penalty was assessed when we send out a notice of alleged violation because we have found that there's a violation that was made by the midwife, then we, in that notice, we will offer a settlement agreement. And in that settlement agreement, it ultimately is a reduced penalty, and it will result in an agreed order at the final end. So that shows that there was an agreement by the midwife and the agency on the resolution of that case.
Okay,
It didn't
perfect.
go
I
to hearing.
understand. Thank
Yes.
you.
Yes.
Kristen Bowers speaking. I have one last question, I think. When a complaint is filed, what is the standard communication timeline with the licensee? Like, how are the updates provided through the whole process? Is there an update that is given to the consumer? Is there an update that's given to the midwife? And as far as are we keeping track of when I know that we're keeping track of when they're opened and when they're closed, but where they are perhaps on this timeline of being processed, like are we keeping track of how long each case has individually been opened?
This is Shauna Almashuk, and yes, we do keep track of how long the cases are opened. And we try to work our oldest cases first. Also, in addition to keeping our cases that with the highest priority at the forefront as well. So we try to do our oldest cases and priority one cases together at the same time. In terms of so I believe you asked if like how often we communicate with the licensee and with the complainant. So once the case is opened, a letter is sent out to the licensee and to the complainant to notify them that a case has been opened. In a very rare circumstance, the licensee may not be notified if we've been asked by law enforcement not to notify the licensee because of an ongoing criminal case. And then as the case is going through the process, there will be periodic letters that go out, I believe, quarterly to the licensee and the complainant to notify them of we're still working on the case. Did I answer all the questions?
Yes, thank you very much.
Dr. Guillory, did you have another question?
No, I do not.
All right, if there's no further questions, we can move on. I'll call on the Compliance Division, Anna Clark, Program Specialist.
Good morning, Advisory Board members. My name is Anna Clark, and I am here to give you the Compliance Division staff report. For our personnel update, our team has had a few changes. Steve Eager was promoted to manager in November of 2024, not last year. Please note that's a typo in my staff report. Ari Acevedo was hired to fill Steve's vacant position. I was previously with the advisory board team, so if I look familiar, that's why. But I was promoted to team lead of the health and wellness team last January. And I am also the main contact person for all things advisory, all things midwifery. For current projects, staff are busy with the bill implementation process for everything that was passed during the 89th legislative session. We had several bills related to the health and wellness programs, but only two directly relating to midwives. The first is Senate Bill 912, which pertains to the continuing education compliance of our licensees through a CE tracking system that TDLR will design. The bill takes effect on September 1 of 2028, which is good because the system will take some time for us to create. The other is Senate Bill 1044, which pertains to the newborn screening test. Midwives will not have to do anything extra because of this bill. Testing for the Duchenne muscular dystrophy was added to the list of testing given through the newborn screening test, which y'all already do. I attended a site visit with staff from our E&E divisions and licensing division and our subject matter expert to review the MTC School of Midwifery course here in Austin. This is a new course taking over for the previous one, Beautiful Beginnings. We spent the day at the school. We sat in classes, met the director. We talked to a few students. It was a very nice day. Also, staff participated in the 4-year rule review. Every 4 years, TDLR reviews our rules to make sure that they still align with the current program statute and requirements. Staff also assisted other divisions with questions that come from licensees and the public. For outreach, Erica Rodriguez and I attended the Midwifery Today conference in March of last year. We were lucky enough that the event took place in Texas as it is a national conference. This year, it's going to be held in Minnesota, so I don't think we're going to be able to attend. But we had a booth set up to answer any questions that Texas midwives may have had. And we also had the chance to attend some seminars, including one that I found really interesting on water births. We're also working on the next edition of the TDLR Health Monitor newsletter, which will be published in February. And you can find the October edition as well as older editions on the main TDLR page. Just scroll down to the box titled TDLR Health Monitor. You can also sign up for email updates to receive them directly in your inbox. Erica and I are planning on attending the NACPM virtual conference in May and the Association of Texas Midwives conference in November as well. If you have any ideas for articles for the Health Monitor or know of any outreach opportunities that you would like us to attend, please feel free to let me know. This is the end of my report, and I'm available to answer any questions.
This is Kristen Bowers. Thank you for that report. I also appreciate you guys going to the Midwifery Today conference. That's really awesome that you guys can be involved in that. I wanted to get a clarification following the new legislature that came out that would affect us. Um, I thought there was also one relating to the new CMV testing. It might only affect some midwives that are operating out of birthing facilities. Was that also something that was going to be included on the current project, or
CMV, what does that stand for?
the cytomegalovirus testing that's performed before usually before they're leaving our birthing facilities? I wasn't sure if
I
that was
am
also
not familiar.
applicable.
I'm sorry, I am not familiar with that, but let me do some research and I will get back to you on that one.
Perfect. Thank you.
Yes, ma'am.
Is there any other questions for Ms. Clark? All right, if there's no further questions, we'll move on to field inspections. I'll call on Juan Munoz, Region Manager.
Good morning, everybody. My name is Juan Munoz. I'm a field manager for the Central Region, and I will be covering our report today. I'd like to say we're saving the best for last, but there wasn't a whole lot of activity for fiscal year 2025, as you can see. We also did have one inspection that was mentioned by Anna from compliance just a minute ago. And then that was for an initial inspection that we did back in October. Pending any of your questions, that's all we have for our inspection report.
Any questions for Mr. Munoz?
Is there a guideline for when field inspections are done? Is it based on new schools? Is it based on a cycle rotation? Is it based on a complaint about a school? Like how does a field inspection get scheduled, and what's the expectation for field inspections?
Well, so we always make ourselves available. There is no requirement for us to inspect the schools from our end, but we do assist for like initial school inspections, as Ms. Clark just mentioned in her briefing, where we bring our education department with us and compliance. And then if there's ever any reach out from our enforcement division that has a complaint and they need some assistance, we also provide assistance. So we make ourselves available. Any requests they have for us, we're always available for those.
And what does a field inspection include?
Well, there is a basically we just for the field inspection for if we do a initial inspection, we're just checking for the basic requirements for facility requirements, any documentation that's required, the curriculum, those kind of things, and that's probably a better question for as far as like curriculum and some of the other stuff for compliance. But that's it's very limited to what we do is just again just making sure the school is ready to operate. And then anything else that we do after our pre-license or before they're licensed for their school, and we based on whatever the reason we're going back for. So if it's a complaint, then we're looking for whatever that complaint information is, and we're going to audit that information to see if there was a violation or not.
Okay. Thank you for that clarification.
Sure.
All right, if there's no further questions, we'll move on to the agency update from General Counsel Doug Jennings.
Thank you. Thank you, Chair Hooper, and hello, everyone. My name is Doug Jennings, General Counsel. Just want to give you some information about related to our agency-wide update. As of September 1st of last year, TDLR now serves over 1 million licensees in the state of Texas. And during fiscal 25, and we talked about some of this during the enforcement report, the agency fielded more than 12,000 consumer complaints and conducted more than 7,000 investigations, and that resulted in about around $800,000 in customer and restitution. You heard a little bit about some legislative updates. Obviously, you heard some about the bills that affected the Midwives program. There have also been some others that we want to bring your attention to. If you've been watching the news during last legislative session, probably aware that the Texas Lottery and Bingo regulation of those programs has moved to TDLR. Interestingly, the lottery generated $1.8 billion for the state in fiscal year 2025, and that's from a total of nearly $8 billion in total sales. And so and this is vital information to have where those revenues go. There are two major buckets that these revenues go into, and so the first is public education, and around 1.77 billion actually of those revenues were contributed to the Foundation School Fund. And that is a fund that supports Texas public schools and includes teacher salaries and school operations. And we had a record 31.1 million that was provided to the Fund for Veterans Assistance through those lottery sales. And that fund supports grants for organizations that serve our veterans here in Texas and their families. So that was the big, the giant change legislatively for the agency. We also added one program to our roster, and that was Senate Bill 1036, which created a new program relating to the regulation of solar retailers, residential solar retailers. So that's going to require some registration and licensing by the folks that run companies that provide consumers with those solar energy solutions, and also have regulation of the salespersons. That takes us up at TDLR to a total of 41 programs under our umbrella. Lastly, and this is going to relate a little bit to some of the conversations that you've had about licensing and CE audits. We are working on a new system. In the past, a new computer system. In other meetings, you may have heard us talk about a legacy systems replacement project. And that simply reflects the fact that as programs have come to TDLR over the past decade and longer, each time programs have come from other agencies, they've also brought with them their own licensing system. So we have, rather than having one unified system here at TDLR, we have a patchwork of different computer systems that come from various transfers of programs. So we received funding and from the legislature, and we are working on TDLR Core is the name for our new combined system that is going to have a lot of quality of life features. It's going to take us into this century, and it's going to help us us field your questions and inquiries more quickly and more efficiently. It's going to help you, the regulated public. It's going to help you provide your applications, provide your documents online through a portal. And it's going to be a real quality of life change for us that we're really looking forward to. We've begun the first waves. We expect that the project will take about 3 years to be complete, but we've gotten off to a good start, and we think that you're going to like what you see. And I'm happy to answer any questions that you might have.
Hi, Michelle Gold here. I have a question. Just because we were talking about kind of the breakdown of open cases, alleged violations, complaints, and stuff. Will CORE also be helping to track those like priority cases and the timelines for cases that are opened and then to completion? Will that be a part of it?
Thank you for the question, Ms. Gold. I think from its initially, I do not think that it will. We have another program that we use that both enforcement and general counsel use called Legal Files. I would imagine that there is. I'm not an advanced user. I know I go in and check it every day to read and to review documents. I know that it has some pretty sophisticated reporting. And so there may be some possibility to do that with our existing system. I'm not sure. But we have spoken about some potential, once we have the TDLR core system running, perhaps inquiring into some case management components. But that would be, I think, a separate procurement. We'd have to figure that out. If Legal Files meets our existing needs, we may not need to do that, but it's something that we will be looking at.
Kristen Bowers here. I was just going to ask, do they have an expected, I mean, I know it's really early, probably on, do they have an expected time that this is going to be implemented?
Miss, let's see, I know that we have begun, we are putting our first wave of programs into the system right now. And I do not know when the Midwives program is anticipated to be added, but I will find out, and I'll make sure that the board gets that information.
Thank you.
Thank you. Thank you.
All right, thank you. There's no further questions. We're going to move on to item G, a discussion of proposed changes to informed choice and disclosure statement required by Occupations Code 203.351. So I'll call on Assistant General Counsel Athena Ponce.
Hello again, everyone. Hopefully, when you all received your informational packet prior to the meeting, you were able to see the existing consent form in that packet, followed by the proposed draft consent form. Did everyone receive those documents? Okay, so I'm going to share my screen just to go over those and point out some proposed changes to the forms. For your information, when you look at the existing form versus the proposed form has several lines that include underlying font. And so right off the bat, you will be able to tell that that's what proposed changes are. And so I'm going to try to share my screen right now, and hopefully it will pull up these PDF documents from the packet. So can you all see this PDF that I am scrolling through that shows what would be the existing form under Occupations Code 203351?
Yes.
Okay, it's got June 2023 down there on the bottom. And so what I'm scrolling to is the proposed updated form. You'll see that there's some boxes or sections that don't have any changes to them, no new and underlined language. On page 2, you will see here in the top box underlined under the I may not category, we are proposing to add perform phrenotomies and perform in abortion as actions that midwives may not perform. And if you compare this box, the existing language that's not underlined at this point, you'll see that that language lines up with statutory prohibitions, and that is the same source of information that we used to add perform phrenotomies and perform an abortion. So for example, the phrenotomies category, that comes under, prohibition of 203.40 or 203.401.3, one of the prohibited practices under like surgical instruments, and it would be something that midwives cannot perform, and which is why we have proposed to add it to this list. Following that, we have an information language for clients so that they have more information about what it means whether a provider does or does not have professional liability insurance. So we have sort of a definition here, and then more background information as to the implications of having or not having professional liability insurance. And so this, if the form were to be sort of adopted or used by the agency, all of this underlining would go away, and this information would be here for the client's use and for the client and the midwife to sign once the information is provided. We're also proposing to include this box of prenatal insurance provided by the state of Texas, just so that when clients are seeking these services, there is a very direct and clear information and link to where they can seek insurance through the state if they so qualify, with the explanation that should they need medical care or a transfer to a hospital, this is something to look into to possibly have to make sure that they are prepared in those instances. And then you'll see on the next page, there's already a non-transport medical backup information and information about hospitals and the existing form that's on the TDLR website. But we've just made it a little more robust to include the address, the unit and or floor of a potential hospital, facility name, and unit phone numbers, just so that this information is already on hand for clients. And so in the case of a transfer, they're not confused about which entrance to go to or which floor they should be going to. I know there have been some confusions about ER versus labor and delivery, for example, or not knowing what entrance at a hospital to go to when time is of the essence. So that's why we have proposed to include this information. And you'll see here proposed language at the bottom that is strongly encouraged that someone who may drive you become familiar with the location of the hospital, including by driving to the location and visiting. And it is encouraged that you pre-register at the hospital if possible and prepare a bag to take with you in case of transfer, just so that transition process is swifter and communication is more efficient. And so, people in this emergency situation, it's reducing the number of decisions and information that they're having to process when they're going through this emergency situation and trying to get to the hospital as soon as possible. So if anyone has any questions, we are happy to answer them, or any feedback as to what you think of the proposed changes, or if there's anything that you would suggest.
Hi, this is Mike Nix. I overall approve, all the changes look good. I think there's probably some clarification needed onto the prenatal insurance provided by the state of Texas. I think, first of all, I think that heading may be a little too, because really, I think this is talking about prenatal insurance in general, I believe. But then it says, even if your midwife is not covered by insurance, it may be necessary for you to visit a medical provider. I'm not, I think that might should read, even if you are not covered by insurance, or if we're talking about medical malpractice with midwife and personal health insurance, you need to include, even if both cases there. But I think that this is more related to the maternal health and prenatal insurance that may be provided by the state of Texas, but the heading as prenatal insurance provided by the state of Texas is probably, the heading I think probably should be prenatal insurance. And then it talks about that, and then another like subheading that says this can be provided by the state of Texas, and then have that contact number underneath there.
Okay. Okay, this is Athena Ponce, and we'll take those comments into mind and see about changing that or clarifying some of that, and seek out more feedback. And it looks like Ms. Bowers has a question.
Yes, this is Kristen Bowers. I just wanted to go over some of this and just review. I know that all of our midwives use this form, but just to get some clarification, um, the intent of the informed choice and disclosure statement presumably is so that patients, clients have a full understanding of the scope of practice and the experience of the midwife, and also, how to contact if they need to reach out to file a complaint and of those natures. Um, but could we clarify which elements of the revised form are statutorily required versus which ones are being added for policy or educational purposes? Um, it it's This is a form that we go over with clients at consultations, which is when we're initially meeting with them. And some of the additional verbiage or add-ons seems really heavy, and a lot of information to be processing, like, oh, hey, great, it's lovely to meet you. My name's this, you're this is what you're wanting, this is what we do. Oh, by the way, blah, 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 all on this form. And we typically do go over insurance with patients anyway. And we do encourage them to make sure that they have some sort of coverage if they can apply for coverage and be accepted. We do want that to be covered. Um, but if this is an informed choice and disclosure statement that is specifically for the intent of informing people about the midwife, I'm not quite understanding the point of adding in the insurance information in the informed choice and disclosure. So I would just like to verify if that is being added as a policy or as an educational option, or if that is something that's going to be added to the form because of a statutory requirement.
Okay, this is Athena Ponce. I am checking the statute itself requiring particular language in the form to see if the information requiring malpractice insurance, is that the type of insurance that you're inquiring about to be included on the form?
This, this question would be specifically the pregnancy Medicaid CHIP insurance. The malpractice insurance, I have a separate question for actually.
So the prenatal insurance provided by the state of Texas, that section that I went over, I do not believe that that is specifically required by statute. There are requirements in statute that at a minimum must be in the information form for compliance, but by policy, I think you sort of implied that policy versus statutory requirement. By policy, more can be added. It is a TDLR form, but at a minimum, what is in the statute must be added. The reason that we propose to add this is so that clients just have a very clear and readily available source of information as to how health insurance can come into their pregnancy and how to seek it out if they need it, at least through state of Texas sources, since we're a state agency.
Kristen Bowers, I guess just to follow up on that question, um, presumably then would it be better to add on not an option, but a policy that requires midwives to offer pregnancy Medicaid and provide information on how or CHIP or insurance in general for them to obtain it versus potentially adding more verbiage to the informed consent and disclosure so that we're not overwhelming them with all of this information and we're losing the point of the document. I feel like the point of the document is to inform them about the midwives' experience, what they're allowed to do, what we're not allowed to do, and also how to file a complaint. And when we add the extra verbiage, sometimes it seems like they might just gloss over, their eyes just go shady, and then all of a sudden we've lost them and we're missing the uh true need for the document. We're missing the point of the document. I guess I was just wondering if we could potentially look at not adopting it with the insurance added in and instead have a secondary perhaps policy added or looked at or investigated as being make sure you're offering um, or giving information as an informational handout to people so that they can have that information because making sure that they have insurance if they needed it is very important, obviously, as well.
I think this is Athena Ponce. I think if that were to be made a requirement of practice and communication with clients, that is something that would need to go through the rulemaking process. And that is something that people are certainly free to discuss. I don't know if that could be discussed at length right now during this meeting. It's not a specific agenda item. Another GC could weigh in. That is something to keep in mind and for us to consider the balance between information on the form or information required by rulemaking that will take some time to develop and require commission adoption.
Mike, next, I'm going to need to take a 5-minute break.
Destiny, do you want to take a recess for 5 minutes? You're muted.
Yes, we can do that.
Okay. So do you want to say what time we're breaking and to return?
Okay, we are going to recess at 11:30 and return at 11:35.
Gretchen Robinson.
Present, just waiting on video.
Okay, having a little technical with that. Jennifer Kelleher.
Present.
Michelle Gold.
Present.
Melissa Bates.
Present.
Dr. Guillory. She may not be back yet. Dr. Nix.
Present.
Presiding Officer Destiny Hooper.
Present.
And I will keep an eye out for Dr. Guillory.
So we will resume item G. We were in discussion about the informed choice and disclosure statement. Yes, Ms. Bowers?
Yes, Kristen Bowers. Um, Thanks for the recess. I just wanted to continue. I know that we had talked about prior to the recess about the prenatal insurance. I'd like to move on to the section that was added with the extended malpractice insurance. Um, what problem or gap is this expanded language intended to address? And is there also a statutory mandate for this level of detail that is being added to the ICD?
This is Athena Ponce speaking, Assistant General Counsel. There is not a statutory mandate. I checked the statute to include information about the professional liability insurance. What is in the statute is at a minimum of what is supposed to be in the informed consent form. The rule for the midwives, 115121 informed choice and disclosure statement says a midwife must use the form prescribed by the department to meet the written informed choice and disclosure requirements of Section 203.351 of the Act. And the reason that we were proposing to include this expanded language is because we had heard through public comments that clients who had had poor outcomes or who had believed that they had had poor outcomes really were not, they did not feel that they were aware about the remedies available to them and how they differed between a midwife and someone with a medical license when it came to their care and the remedies that they could use for redress or to try to respond after the fact. And this information about the difference between medical providers and midwives, and that midwives frequently do not have malpractice insurance coverage, does not seem to be a subject that is, sort of widely communicated to the public. And because there was already information on the form about malpractice insurance, it was, a check yes or no whether the midwife has it. We wanted to provide expanded information so that a client is fully informed, can make an informed decision about how this factor affects their care, what can happen after care, and what is available to them if they experience what they consider to be a poor outcome or a loss.
Melissa Bates, just in speaking to that, again, if it's not required by statutory, and I don't know, this may not be the day to do it, but like, I don't agree with adding this expansive language because I also think it adds confusion, and it's really on a case by case basis. Like it depends on what happens in court, so to speak. So, because to say this makes it read like to one person, okay, if my midwife doesn't have malpractice insurance, if there was a claim, she'll pay that personally. And that's not necessarily how it always works. And so that's a lot of speculation. And it's a lot to get into, as Kristen was mentioning, when you're doing like a consultation. It's you're going down a rabbit hole that it's speculatory.
So is there potential improvement to the language that you see that you think could make it more clear as to what you would want communicated to a client?
I think that the way it currently stands with just indicating whether or not the midwife carries malpractice insurance should suffice at this time. If the client or potential client had additional questions, then that would be for the midwife to kind of walk down that avenue with them. But even at that case, I mean, it's speculatory because cases are handled individually. So I just don't think this form is the place to give more information. I think it's yes, I carry it, or no, I don't carry it.
Gretchen Robinson, if I can for a moment. My concern is more that this can be interpreted as an implicit warning rather than neutral information. A client's rights, that information, thank you, already exists in multiple avenues. If a client has questions about what is malpractice insurance, I see here that my midwife does or does not carry it, she has a plethora of access to find out that information, and obviously the legal right to ask us any questions. I think there's a risk of misinterpretation, future legal exposure. I've got a whole list on this one because this is something I have been sitting and really ruminating on all weekend. Um, it feels, my words here, it feels like it is singling out midwives. Um, I've had an OB care, I've had care with multiple other modalities. It's not explicitly written that, hey, why don't you ask your midwife right now? In the event I decide that I don't like you or you did something wrong, how exactly are you going to pay me if I sue you? Explain to me your financial capabilities in the event in a few months I decide I want a refund and you're not giving it to me. And because it doesn't clarify what your malpractice is for, it just says, hey, you can sue her. Why don't you ask her how she's going to go about handling that in the event she doesn't have malpractice insurance? We're already in a highly litigation society as it is. We're stating we have it or we don't. I think it would be reasonable to maybe put a definition of what malpractice insurance is if that makes everybody happy. I think most people understand what that is, but you want a definition added? Yes, we have it. No, we don't. Sure, that's reasonable. But specifically in bold lettering saying, why don't you go ask your midwife how she's going to handle this if you decide to sue her and she doesn't have coverage, just feels really, yeah. I'm really, really not okay with this. I'm totally open to a compromise, but as it is right now, this does not feel okay whatsoever.
This is Athena Ponce, speaking, Assistant General Counsel. So what your suggested proposal or feedback would be at the most to maintain the language that's from the existing form, and then perhaps a definition of what professional liability insurance is.
If that's what the initial goal was of making this proposed change, if the goal was, hey, we want to clarify for the general public who maybe doesn't know to go Google these questions or call and ask or ask their midwife, just ask. If the intention is to give more information about what this is or isn't, okay, give the definition of what malpractice insurance is. I don't personally think even that's really necessary. I think the way that it stands is perfectly fine. We are required by law to go over this form line by line with our clients. I, for one, do that. I've never ever had anybody come back and say, well, what does that mean? Or where do I find that? They're welcome to, but it doesn't seem to be a source of great confusion in our society. This verbiage can be very confusing. And you're stating legal definitions here that are not, as Kristen already said, it is not always, or sorry, somebody said, it really creates the risk for misinterpretation, for legal future, legal exposure, civil laws. I mean, you're not gonna, that's creating a whole nother page if you really want to get into it. Think it's simplified the way that it is. If you need a definition added because you feel like that's the main issue, the feedback you've been given from consumers is we don't understand what this is, then put a definition. If that's not really what it is, then no. I don't think that this is wise, necessary, and in some ways legal.
Destiny Hooper here. I was looking at the difference between them, and I think just that last sentence that's bolded and underlined, a client may at any time ask their midwife about their financial responsibility arrangements in the event of a malpractice claim. Maybe just that one sentence is all that's needed. If they have questions, it opens the door right there for them to ask them, and if not, they can just move on with the form.
Michelle Gold here. I just wonder how that last line, Ms. Ponce said that one of the reasons for putting this in was that this could affect their care, clients' care. And so I just don't know how that last line would affect the care positively from the start between the midwife and client, how that would set that up to be a positive and moving forth a trusting relationship. So I agree with Gretchen, Melissa, and Kristen that I don't think that this is all necessary.
This is Athena Ponce speaking. Were you asking a specific question about if
No, I was
this
just
would?
No, I'm sorry to interrupt. No, I was just expressing my opinion on record.
Oh, okay.
I do actually have a question regarding that. Um, if I may, Kristen Bowers speaking. Has there actually been, I know that this form was made, it says in December, has there been an evaluation on how this revised language actually may affect client perception during consultations, especially when we have, first time midwifery contacts, they're new to this. Before this was to go, if it was so desired that this is the form that TDLR would like us to provide. Um, is there going to be an evaluation on how this language is affecting the perception of our, um, potential patients or clients that would be reading this when they're like, is this going to overall? I feel like it does overall give a negative connotation to midwifery and midwifery services in general. If you don't like anything, you can just sue your midwife and you can ask her about, you know, how she's going to financially pay for that. I feel that does have a negative connotation, like others were saying. However, do we have any actual evaluations that were perhaps that could document this before we move forward so that we have evidence of which way people feel?
So this is Athena Ponce speaking. The reason that this language was expanded upon is that we had heard public comment that the information that clients receive concerning redress or remedies after there has been a loss during care, that they really were not fully cognizant or aware of the differences between medical care and midwifery care in that respect. And so, in response to public comments to that concern, we wanted to ensure that clients had a clear in writing the difference between medical licensed care and, I won't say that's always the case in terms of whether malpractice insurance is available or not, but just to make sure that the client is informed, because ultimately the public health and the client is the one who needs the information for their care to make decisions affecting their life and their health and their infant. And we wanted to make sure that that information was robust and available to them at the outset.
Kristen Bauer speaking. I can definitely appreciate making sure that the client has all the information to make choices about their care. We all agree that informed consent is, you know, the utmost importance throughout our all of our prenatal care, all of midwifery care in general is really focused around making sure that our clients have as much information and all the information to make true informed decisions. Um, I think perhaps, however, if we were to continue with this verbiage, with it not being exactly accurate in on a case by case basis, presumably before signing a form, we could almost say, if you don't understand the meanings, like we really shouldn't be signing these forms. um, you should consult. Like if you have a question about malpractice insurance and how that might affect you, perhaps we should be consulting with they should be consulting with an attorney about what that means when they actually sign. I mean, there's when I sign a form and I'm going into an office, if I don't understand something, I can ask for clarification. And if I don't feel comfortable, I don't sign it. I might get further clarification and then schedule to come back later if I don't like what's on a procedure, or like just like in a dentist office like I went to recently. I was looking at it, I was like, I don't quite understand this. Can you provide clarification? Um, but ultimately, at the end of the day, I feel like there is some consumer responsibility in their education on what malpractice insurance is. In fact, we can explain it, we can define it, like Melissa Bates or Michelle was saying, sorry, I'm not sure who said the definition, adding that definition. I think it was Gretchen, maybe. Uh, Apologies. But adding in that definition of what it is, but moving forward, like further education on what that would look like because I mean, this is potentially a very rare event. Should something happen, then they would need to seek legal counsel.
Well, I'm sorry, Gretchen Robinson, understanding that this form, it's not a release of liability. We're not saying we don't have malpractice insurance, and also you're signing that and understanding that and releasing us from liability. That's not what this form is. But including this verbiage, it's not doing anything to enhance client safety, informed consent. It's just throwing in unnecessary legal commentary. It's discriminatory, I feel like, to us as midwives. This verbiage is specifically seeking out, um, obviously midwives, but also, I don't know the stats, but I'd be hard pressed to think of 5 midwives that I know that carry malpractice insurance. Um, it feels like this could be confusing and possibly just coercion. The verbiage on this is a warning. It's a dark alert, warning. At the minimum, that bolded language at the bottom desperately needs to be either taken out or strongly changed. But I'm still just not getting, as Kristen said, there is a client responsibility as well to understand the basis of their rights. This is not a waiver. I don't carry malpractice insurance. You're welcome to ask me how horrible a lawsuit would affect me, should that ever happen. It's not going to be pretty, but I don't carry it. And I assume all liability and risk, however that's going to look. I'm not going to put that in bold, and I'm not going to make midwives look extra dangerous. You better make triple sure you understand, because your midwife is that dangerous. This went from, hi, I'm Gretchen Robinson. I've been licensed for 7 years, and this is how many births I've been to, and here are the things I can and cannot do for you. And here's my backup, and here's the people I work with. Also, bold language, it just seems so out of place here. Just
So,
my 2 cents.
this is Athena Ponce responding. Based on your comment, you said if you are operating without malpractice insurance that you are personally assuming the risk. And if I'm misconstruing or misreporting what you said, you can correct me. But then with the language at the end that says, without malpractice insurance, the provider is personally responsible for the amount of any settlements or judgments owed by law to the client, be incorrect? Are you saying that that doesn't align with what you said about assuming the risk?
Sorry, I'm trying to pull this up at the same time that I'm listening to you. Let me go back to the form. No, I'm not disagreeing.
Hey,
If
Athena,
someone to
could you
follow,
could you share your screen and show that
yeah, I
that
have it pulled up
insurance
on my
paragraph?
phone really quick so I can take a look at it, but I'm blind, so let me take off my glasses.
This is Athena Ponce. Was I asked to share my screen?
Yes,
Yes,
this
if
is
you
Anna
could share.
Clark, TDLR. If you could share
Okay.
your screen and
Yes.
hold on, my video is off. Oh.
So
If you could share your screen and show that professional liability insurance section so everybody can see exactly, and maybe zoom in a little because I'm blind too.
Okay,
So the definition I was saying, it's the first line. Professional
Yes.
liability insurance, blah, 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 is a method of providing compensation. And then from there, drop down to, I have this or I don't. Add client initials. That seems incredibly sufficient right there. You've got a definition of what this is. I either have it or I don't. As a consumer, if I'm reading that and I say, oh, okay, I know what this is for, I know what this means, I also note that my provider doesn't carry it. I know I can then ask a question. Oh, shoot, my video went off again. I know that I can then ask a question or do further research myself if I don't feel comfortable asking a question, which if I don't feel comfortable, I shouldn't be with that provider. But the whole center section just seems incredibly unnecessary. I think the top line, your check boxes, short, sweet, to the point, and definitely not in bold. Like, do we have much else on this entire form that is in bold? I don't know. Maybe I'm just picking. I don't know. I've said all I can think of on it. Thank you for listening to my rantings.
Thank you for your comments. And is there a question from Jennifer Kelleher?
Yes, thank you. Jennifer Kelleher here. I agree with much of what's been said, but as a midwife that has practiced for a very long time, I would be hard pressed to sit in front of a client and explain in any kind of detail what malpractice insurance is or isn't. I don't have it. I don't carry it. It's not part of my practice. It's not part of my offerings to this client that's sitting in front of me trying to gather information about what I can or cannot do explicitly in the state of Texas. So I don't I fully understand and have supported the single line item of either I carry malpractice insurance or I don't. The other portion of that is that I would also be hard pressed to sit and have a conversation with anyone about how I would financially handle litigation. One, because I expect it in the last 20 years of practicing, that has changed. But in addition to that, unless we've been through that, do we really know? I don't know that I would be able to address that in any kind of great detail, much less in writing. But for me to explain what malpractice insurance is or isn't to a client, I don't know that that falls into my scope of obligation. Thank you.
Is there any other comments for Ms. Ponce?
I have some not about the professional liability insurance. This is Michelle Gold here. The revised enclosed informed choice and disclosure statement at the very top, it took out the neonatal resuscitation certification expiration date. It just left CPR. I feel like maybe if I was a client, that would be pretty important to me to know that they're also up to date on their NRP, their neonatal resuscitation skills. So that's just a comment I just wanted to make about that section. And then you mentioned the phrenolotomies. I always have trouble saying that word. Is it not implied that we can't do them because we can't use surgical instruments? Is that would that be a redundant statement? Like we can't use surgical instruments, so therefore we can't perform the phrenolotomies.
It is, this is Athena Ponce speaking. It is redundant in as much as anything else that is listed here in the I may not section is redundant by repeating the statute.
Yes, in the informed choice part of the occupation code, we're supposed to list our skills and practices. And so that's part of like what we cannot do is that these are not a part of our skills and practices. So these are the things that we're prohibited from doing. And so I mean to say, is it redundant within that statement, within that prohibition statement? Like, do we need to add phrenolotomies? I mean, the same could be said for performing abortion since that's, a statewide, nationwide thing. But specifically for the phrenolotomies, I just wanted to have a conversation about it. It's not a deal breaker for me, but I just wanted to ask about that. And then why was the neonatal resuscitation part removed?
So this is Athena Ponce speaking. I'll try to answer both your questions about the phrenolotomies listing and the neonatal resuscitation. The reason phrenolotomies was specifically suggested to be added is, to my knowledge, and that there are organizations or individuals who are providing training for pay for licensed midwives to learn how to perform phrenolotomies. And it is possible that midwives are performing phrenolotomies, even though it is not permitted by statute. And so this specific language allows clients to specifically understand a phrenolotomy is not allowed, rather than requiring them to make an inference based on use forceps or surgical instruments, unless cutting the umbilical cord or providing emergency first aid during delivery. This is for clients to know what should not be occurring during care under statute. The same as abortions. And because there have been reports that midwives have engaged in abortions. And then in terms of the CPR language, are you talking about the first box on the very first page where it says my cardiopulmonary resuscitation certificate CPR?
Yes.
Okay, I'm looking at both forms, that same page and that same box, and they both say on my copy, CPR expires on. So are you talking about neonatal resuscitation or?
Yes.
Okay. Yes, I do see that line is missing, and I will have to see why that was removed. I don't know if I personally made that change, but I do see that there's a difference between the two forms, and we will look into that.
Yeah, I didn't know if it was a word count thing because under the occupation code, it does say the informed choice statement needs to be under 500 words or less. And so I didn't know if y'all were trying to get it under that word count or not, especially with the addition of the professional liability. But to me, that would be more important to know that the midwife is up to date on that, and that it is a valid process too. Had another question about something. Oh, the medical transport section. I had a couple of questions on. I do think that the clients having knowledge of where to go and what hospitals we normally transport to, having two of them are great because sometimes we go to one over the other depending on the situation. You said that the expanded version of this was brought up because there were some complaints about whether people need to go to ER versus L&D, like there was some confusion around that. I don't know if this fully addresses that specific component or that specific subject because that varies based on hospital to hospital, whether you go to the ED or whether you go to straight L&D. It depends on the collaboration and the relationship between the hospitals and the midwives. It also depends on the hour of the day. Like I have a hospital that we can go straight to L&D if it's before 8 p.m., but after 8 p.m. we have to go through ED. And so it doesn't quite relate to that very specific question. Again, I do think that people need to know where to go in the hospital in the event of a hospital. I will say, since we do this at the very, very beginning of contact with a client, that we usually address this again. Most midwives address this again later in pregnancy because they're not going to remember this from 10 weeks. And then all of a sudden now we're at 41 weeks and we're going to the hospital. So I do think that is good to encourage them to become familiar with the hospital, prepare hospital bag. That's great. But the breaking all of that up might just be a little bit excessive. Is just what I want to point out on that particular thing. And then the pre-registration part. What benefit? I talked to, let me just give you a little backstory. Sorry. I talked to somebody at one of the hospital systems that we work with, and she talked about how pre-registration can speed up the process of somebody coming in. Like they maybe not have to wait as long on labs and not have to wait as long for other interventions. And maybe one of the MDs on the board can help also clarify this. But as far as like emergency transports, I don't know how that would help in that situation because they're going to do what they need to do in an emergency situation, regardless of whether someone pre-registered or whether they have, answered the questions about when do they take their prenatal vitamins, what's their insurance, all that stuff. So I don't know. Could you explain the pre-registration and how, if y'all looked into that, like if it would actually speed up the transfer of care process, especially in emergency situations when we really need these interventions and tools the most?
Before they answer that question, I just want to simply say, I'm not sure what happened to neonatal resuscitation. That's sort of imperative. You're talking about maybe 5 or 10 minutes of the baby being there without a resuscitation. So that's critical while we're waiting for the 911 emergency ambulance to come, if that's what we use. Most of the time, and that was my question that you had, most of the time, if you call 911, they will take the patient to the very nearest hospital. So wherever you're delivering, it's going to be right in that area. Very seldom do they go out if you have registered at another place. So I think that'll be very important to look into. And I have to tell you, I work in one of the largest neonatal units around, and most of the babies come in through the emergency room because they're not going to labor delivery. That may be the mother, so I can't tell you about that. But ER and the neonatal, the baby is coming to the ER. We go down and bring it up to the NICU. So that's all I can add to that discussion.
We had a question from Jennifer Kelleher.
Thank you. Just a couple of different things is that I'm wondering, I feel like this informed consent document, and I'm referencing specifically the phronomy and along with the performance of abortion. If the intent of these line items are to make sure that Texas midwives realize that this is outside of the scope of a Texas license, then maybe that belongs more on our licensing documentation, that we sign something, that there's a document or a line item added for us to initial or to sign when we renew our license or apply for a license. That this should not be a document outlining for the midwife what those specifications on those cannot do or expected to do. This is not a midwife form. This is a client or patient form, was my understanding. So I wonder if that would be more appropriately defined or exemplified or bolded in part of our private documentation with the state. And again, this goes back to the responsibility of the midwife as far as knowing what her laws, rules, and regulations and protocols are. And then my second thought was to address um, the portion of the informed consent that talks about where we would go in the case of an emergency and what that looks like. And every area is going to have its policies and protocols. And I can tell you with personal experience that living in an area where there's a very large medical center, some having different levels of NICU, some not having any labor and delivery, some having labor and delivery and no NICU, that when it comes down to it and I call 911, it's that EMS person that is deciding where we will go. And it is often, as often as I call 911, which is not often, not the closest, not the closest hospital. And I don't have a say so. Even if I go to them and say, I have a doctor ready to accept me at this hospital that is actually closer than the one you want to take. They're like, our hands are tied. We've been told where to go, where there's availability and opening, and they go where they're told to go, regardless of my opinion or my feedback. In addition to that, in in a large city where there are a multitude of hospitals um, and values and expertise, areas of expertise that might be better at one hospital versus another. Sometimes, as a provider with experience, I'm in real time talking to the parents about where we're going to go. Now, I wonder if what belongs on the ICR is something along the lines of specifically in a 911 emergency, this is where we will attempt to go. But I can't always make that happen.
Destiny,
Thank you.
thank you so much. I had also wanted to comment on that. I agree that having like so much space to list multiple places makes the mother feel like, wow, I'm just have like this dreamy emergency situation where I'm just gonna get to go where I want to go, and that's not the case. So I feel like that's setting up this mother who's probably like 8, 10 weeks along to think that an emergency is not really an emergency, in my opinion, with those two options listed there like that. I think maybe something like she was saying, verbiage that just says, in the case of an emergency, it's a case by case, and we will talk about transfers.
So, in response, this is Athena Ponce. Earlier, Mrs. Gold had made a comment, or she asked what was the basis for encouraging pre-registration at the hospital, or what would be the benefit of that. That idea was taken from the Oregon Perinatal Collaborative write-up that they did on improving transfers between community care in hospitals. And I can share that screen if you all would like, but on page page 82 of that document, there are recommendations for community midwives. These include community midwives should increase and improve preparation for hospital transfers, which is encourage pre-registration at the hospital, encourage packing a hospital bag, create an individual written transfer plan with documentation of preferences and choices for care, such as newborn procedures, provide education about what to expect in the hospital, use handouts for hospital transfer education, and ask for feedback from clients who transfer and adjust practices based on feedback. So that greatly informed how we proposed to update that section. And secondly, in terms of information for the client and responding as best they can in a very distressing emergency situation where, unless someone is highly trained in emergencies, they are just doing the best they can and their judgment can be clouded. If they have gone through the motions of driving to the hospitals that they may need to go to, know exactly where they're located, understand where certain units are and who to speak to when they get there, that can save minutes of time. There have been cases and enforcement cases that have gone to TDLR where there were lapses and delays and loss of time because a family was trying to simply navigate correctly to a hospital and get seen as quickly as they could. This is for the client's benefit and for them to have an opportunity to understand that if they practice responding to an emergency, they can better protect and prepare themselves. There's no possible way for a layperson to be 100% prepared for an emergency that they are not regularly presented with. But the point is to improve their chances of reducing time that can end up with things like worsening hemorrhage or brain damage from lack of oxygen. And this is intended to be for the client's benefit. And in terms of the question about listing frenotomies and abortions and saying that it is possible that we could include that in the licensing documentation, if midwives are the ones providing these informed consent forms, that means that they would be reading them as well and be aware that they are not to perform frenotomies or abortions. So it seems that that base would be covered.
Sorry, I wanted to refer, my thought on that was that this is not a document. This informed consent document is for the client/patient. It was my understanding that this is not a document intended to outline for the midwife's knowledge of what her scope of practice is. It was not in addition to adding it to licensure line item renewal, but instead of. Thank you.
Gretchen Robinson, really quick, just about the registration at the bottom of the transport. My understanding is the difference between a transport and a transfer. When I think of transfer, I'm thinking I am transferring care. This mom has risked out probably some point, second or third trimester. I need to transfer her care to another provider. That would address the backup medical provider at the very top of that, which, by the way, I also don't know very many midwives who have an established relationship or agreement with another medical provider to provide continuous backup arrangements. We usually just say consult upon need. But the rest of this verbiage here is addressing a transport. And for us, a transport is an emergency situation that is typically in labor or the IPP. We are transporting this mom. This is an urgent need. Pre-registration at a hospital of her choice and desire is meaningless. I believe I'm the only one on this board that's in the DFW area, is my understanding. And I'm very rural at that. Baylor Dallas is our safe haven as far as midwives go. Bumsey is amazing. They're also 35 minutes from me. And there's a hospital closer, 18 minutes away. My local EMS is going to go to that closer hospital. I can sell this mom on how wonderful Baylor Dallas is all day long. But if I have to call 911 or if I'm driving her myself, we're going to have to go to Hatchie. So pre-registration, she'd have to pre-register at 3 different hospitals out here just to make sure she's in the system if I have to call 911. Otherwise, she's not in the system anywhere. And there goes my video again. What is going on? So I think the pre-registration is a moot point, and it's really going to put the mom through even more fuss and muss over nothing. But what you were saying about becoming familiar with the location and the route, not a bad idea. I'm actually familiar with the cases you're talking about that were definitely impeded by a misdirection, we'll say. So yeah, become familiar. If I'm telling you the 2 closest hospitals that we could possibly transfer to, that's also client responsibility to assure that they know where those are. It is not on me here. EMS knows the route, I know the route, the family should know the route as well. Listing my backup transfer providers, I always thought was silly because most of us don't even have anything to put in that space. But the pre-registration is really obnoxious. The moms would have to register with multiple hospitals just on the toss a penny in the thing to see which one catches. That's a lot of work for nothing. It's not going to benefit them for sure, because when we get there, they're asking those questions well after mom has already established care and gotten started.
Michelle Gold here. I just wanted to point out that nobody said that going to the hospital and visiting it beforehand was a bad idea. So, Ms. Ponce, just when you made that comment about explaining that portion, I think everybody does talk about, knowing the way for their clients, or having their clients know which closest hospitals we go to, and that we familiarize with that. And it's always a good idea. So I didn't hear anybody else disparage that particular part of it, of becoming familiar with the routes and the locations of the hospitals.
I have a comment from Ms. Bates.
Yes, thank you. Melissa Bates, I was only going to add that I understand the possible confusion if people are going somewhere and they don't know where to go. My only, I guess, concern with that is because the situations, at least the examples people are coming up with that are very much time sensitive, I wouldn't have the client drive themselves if they're hemorrhaging, or if, there's HIE going on with the newborn. That's specifically when I call EMS. And so they're then along for the ride. And anyway, so I just, again, just to have, I guess, on record, I'm fine with the verbiage at the bottom that says they can become familiar with it. But I prefer the cleanliness and the way that the original form was, both for the malpractice and for the transport things. That's all I have.
Thank you. And Ms. Bowers, did you have something to add? Okay.
Kristen Bowers. I think it was all addressed. Thank you.
The only thing I'd like to add is I think it's still very important. I understand transfer, you're transferring the care of a patient to another person. I understand transport. When you have transport and it's an emergency, I just want to put a plug in that you still need that information in transferring. In other words, you may get a baby and you don't know the history. So it's very important to do the transport, of course, but make sure that the transfer of information is there. That's all I'm saying.
Ms. Kelleher?
In addition to that, I for clarification purposes, every situation has its own nuances. And traditionally, if I am transporting either privately or by 911 a patient, as soon as the decision is made where we are going, that becomes the role of my assistant midwife or my birth assistant to get records going, get labs going, get ultrasounds going. I cannot remember, with the benefits of EMR, the last time that I ever didn't have report given and records en route while we are on our way. Like, that information is, and every hospital has their policy on who to give that report to, where to send those records. And I, as a midwife, that it becomes my responsibility to kind of be in the know of the places that I get, what their preferred protocol is for conveying all of that information. But it's not streamlined, and it's not because of my decisions. They are not streamlined. And so if I look up university in my phone, under my notes it has all of the different who to call for maternal, who to call for neonatal, where do I send records. Like, every hospital um, has its own protocol. And for me to include any and all potential protocols in this informed consent, I just don't know is serving the purpose of the informed consent. And so I feel like we need to really just try to stay on task with the intent of this document, that this document is not for midwives to outline in their own mental capacity what their license includes or doesn't include, or how that midwife should, could, or will instigate a smooth transition for her clients. But this is for the clients and the patients to really outline and be in the know of what the limitations versus the expectations their midwife has from a legal rules and laws perspective. Thank you.
Thank you all. Thank you all for sharing and discussing this with Ms. Ponce so that she can continue to work on the proposed changes for the document. We will come back to this document, I believe, after Ms. Ponce is able to go over everything we've shared with her. Is there any other comments or questions about it? Great. We will move on to the H, Standard of Care Work Group Report with the program specialist, Anna Clark.
Good morning again, everybody. Before we get started on this work group report, I wanted to let y'all know I did some research on the CMV testing. It was for House Bill 4882 of the 89th legislative session, and that is only for midwives that are working in facilities and birthing centers. So it doesn't have anything to do with home births or anything like that. So just FYI, but they are required now, blood, saliva, or urine testing. And also I wanted to add something about our field inspections report. We had questions about the site visit that we had. We have site visits before every single new school opens, and then we have a site visit whenever they renew their license. I believe 2 or 3 years. It's every 2 or 3 years. And so well, first they'll give us their application, we'll review all their documentation, their list of students, their curriculum, everything that they teach, their preceptors list, everything like that, making sure everybody is licensed and available to be preceptors. And then we have the site visit. We go with enforcement, no, excuse me, not enforcement. We go with E&E, field inspections, compliance. We meet with the director of the school. We sit in a couple classes. We talk to the director. We go through student files, make sure everything is correct in the student files. For that as well. And if you want detailed information on that, it's in our rules, the midwife administrative rules. It's section 115.20. So if you want a detailed information on what we look for in a course and how to approve a course, it's 11520 on our website. But let's get started on our work group report. On the report, you will see the work group members and the staff who attended. The first agenda item was the MANA dissolution. At the time of the work group meeting, it was believed that NARM was going to take over for MANA, but we learned that the NACPM will be the organization taking that role. I've been in contact with them to obtain documentation on their standards and scope, and we will have everything from them soon. So once we get all of that information from them, we'll schedule a meeting with the work group again to discuss rule changes in regards to MANA. The second and third agenda items are pertaining to prohibited sexual contact and the necessity of a plan for backup care if the midwife passes away or becomes incapacitated. Our general counsel has incorporated these into the draft rules that they are currently working on. Agenda item 4 was a discussion on neonatal resuscitation, continuing education requirements. TDLR will be removing references to sections 1 through 4 from rules 115.13A5. So it will simply state a midwife needs proof of their current certification from the American Academy of Pediatrics or an equivalent of certification, which is approved by the department. And we are looking into approving other possible courses that meet the requirement as well. For action items, General Counsel is drafting rule language based on all the recommendations from the work group, and I am investigating other possible neonatal resuscitation program providers. And that is the end of my report, and I am available to answer any questions.
Does anyone have a question for Ms. Clark?
Thank you very much.
Thank you. Okay, we will move to item I, the reappointment of work groups. We need to reassign our board members to all the different work groups. So first I will list them out for you. We have enforcement, licensing, education and examination, standard of care, and relationship building. So I want us to go one at a time and verify which groups you're interested in being in. And if you are already in groups, if you want to change the group you're in, you are also able to do that. So I see that Carmen shared the screen with us so we can see what we have so far. And if we want to go one at a time and state what you're interested in doing so we can fill in all these empty places.
Quick thing, since I'm already on groups and I have a client coming in, is it okay if I am done?
We have a few more line items to discuss before we're adjourned. I'm not Carmen.
If you need to leave, it's okay. We'll still have a quorum without you.
Okay, thank you.
Thank you, Melissa.
And I think if you need time to think about it, we can also email Carmen what we're interested in if you guys want to do that instead.
I would definitely be interested in being added to the relationship building work group.
Okay, relationship building, that was Jennifer?
Yes, sorry about that.
Okay.
Jennifer Kelleher.
Would you like to be the chair or just a regular member?
Just a regular member for now.
Okay.
Gretchen Robinson. I would be interested in the enforcement work group since I have some previous experience in that area.
I got you down.
I can get my video back. I don't know what's going on with that today. I am so sorry.
It's okay. You keep coming in and out enough to where it's like, okay.
Well, like every time we go from sharing a screen back to everybody, it nixes me out. And then every time we flop it back, it stops me again. I don't know. It's wonky. Sorry.
Okay, looks like we have one more available for our enforcement work group. And that'll just be any items that, like, if they do a penalty matrix or any kind of rules that they handle, you would be a part of that work group to go over those items.
Would this include the midwifery rules?
Is there anybody from enforcement on here that could verify that for me?
Hi, this is Shauna Almashuk. My video was delayed, sorry.
It's
Yes,
okay.
it would be in the midwifery rules, yes.
Awesome. Thank you.
Kristen Bowers, I would like to be added to the enforcement work group.
Great. Thank you so much.
Michelle Gold
Okay,
here.
so
Oh, sorry.
it's okay. I just
I-
wanted to say we've got enforcement taken care of now. So
Great. I'm already on the standard of care work group, but I am interested in the education and examination work group.
would you like to be the chair or just a regular member?
Is there a profound need for the chair?
It just helps, like if there's a report, then you could give that report to the board.
Oh, I see. Yeah. I'll just be a regular member for now.
Okay.
Thank you.
So we've got on E&E, the chair position that's still open. And then the chair position and relationship building work group is still open. It looks like we only have Destiny on the licensing work group.
Would you be more
Anybody?
specific on what's the licensing work group? Sorry, Kristen Bowers, on what
Any
that entails.
requirements? Yeah, any requirements in the rules, inspections and compliance, and other administrative matters.
So do we move on or do we need to fill the spot?
It would be nice if we could go ahead and get the reappointments.
Does anybody want to volunteer to be in a second work group?
I'm also interested, this is Michelle Gold here. I'm also interested in the licensing group, but that would put me on 3 groups. So if somebody else who's just on 1 wants to be on 2 to spread it out a little bit more, but I can throw my hat in if nobody else does.
So, Gretchen Robinson, how often, I don't understand how the work groups operate specifically. How often are they meeting, conversing? Because I don't mind taking on a second one.
Yeah, it's going to
Just
be as
depends.
an ad needed basis when these items come up to get
Okay.
together and discuss them at the time.
Okay. Then I am happy to join Destiny on licensing to assist as needed. I just don't want to bite off more than I can chew. I do work a full-time weekday job too, so I'm
That's
semi-retired as a midwife, but I still work, so okay, I will join licensing as well then.
Okay.
Kristen Bowers, was there another spot on the education and examination work group?
Yes, the chair spot.
I don't mind filling that position.
Okay. And that one includes the task of the midwifery manual. So that should be pretty interesting. Okay, we've got the chair in the relationship building and then one position in the standard of care work group left.
I would be interested in the standard of care work group
Who was
position.
that? I'm sorry.
I'm sorry,
Jennifer?
Jennifer Kelleher? Yes,
Standard of care. Okay.
correct.
Okay, that one rounds that out. So we just have the chair of the relationship building one left.
I can take the chair. That's Destiny Hooper.
Awesome. Thank you, Destiny. Okay, we are all full, and then I will go ahead and get a list to you guys and also include the TDLR staff member that will be reaching out and coordinating for each one of these work groups. So I'll get that to you guys.
Great, thank you so much. Okay, we will move to item J, recommendations for agenda items for the next board meeting. So at this time, if there's any recommendations for the next meeting, Carmen will write them down, and you can also email her if you think of suggestions after the meeting. For the next meeting, will we go over the informed choice and disclosure statement again?
We can put that down for sure. Okay. And if y'all don't have anything, just feel free to email me and I'll make sure that I get it on the list.
Okay, so if there's no other comments for that, we will move to the discussion of the date, time, and location of the next board meeting, which will be Carmen will pull us as a board at a later time for the future meeting. And so that leads us to line item L, adjournments. There
I
being
actually have a
no,
quick question. I'm so sorry to interrupt. I have a quick question on line item K. This is just like a general logistics question. How often, if any, do we actually meet in person anymore?
Just the video conference.
Okay. Was that because I know that the meetings used to be in person, and I know that people have to travel. Like I'm lucky that I'm in Austin, so I don't have to travel very far. With COVID, is that when that changed? Was the video conference?
Yeah, well, historically, that's what I'm seeing. And then we have hybrid, but when we do hybrid, the presiding officer has to be in person.
Mm-hmm.
So, I mean, that's the trade-off there is like, y'all would all, have to travel or everybody would be virtual except for the presiding officer. Sometimes that happens.
Okay, yeah, just wondering because I'm also new. There were 3 introductions, but this is also my first board meeting, and so it just
Yeah.
I don't know. It seems like it might be nice for like every once in a while on a blue moon if we were able to meet in person, since we're all going to be working so closely together. But again, I
I can
understand.
definitely get those talks going.
Okay, I
Yeah.
understand though that people are busy and you have to travel far, so please don't breathe fire on me if you're thinking about that right now. Just putting
This
it
is
out there.
Anna Clark
Thank
with
you.
TDLR. I just wanted to chime in since I was with the advisory board and Carmen graciously took my spot. Yes, we started doing virtual meetings in 2020 because we could not meet in person. And that was continued because of the cost of travel and hotels and things like that. We used to have meetings in the afternoons and in the mornings, and it was just a lot of effort to get everybody into Austin at the same time on the same day. We had people flying in from Lubbock, and we couldn't reimburse them for their flights and things like that. So the majority of our advisory boards are virtual. There are some instances where they are in person or hybrid, like Carmen said, but that is very few. So I think our executive director said from here on out, they should be virtual if they are not already.
So that's
But
across the
yes,
board.
I would love to get y'all like all together so we could meet and chat and talk with everybody and see how y'all are doing in your practices and stuff.
Yeah, thank you.